Good morning. Are you Tori Anderson?
I'm Tori Sam. It's like
What is it?
Sam. They didn't put my correct last name in there. That's my
Okay.
maiden name.
What's your date of birth?
August 14, 2003.
All right. And so this is your initial appearance. Is it Sam? Anderson's your maiden name? Okay. So Ms. Anderson, in clause number 25, DCCR 1165, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from July 31st of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I'm unemployed. I had family come together to pay for my bond.
Okay. Have you been looking for a job?
Yes.
Where have you been looking?
Walgreens, Dollar General,
Okay.
basic retail business.
All right, so what I'm going to do, Ms. Anderson, I'm going to give you about 30 days to see first if you can get a job. So I want you to be applying to at least 5 a week. You should be doing more than that. If you get a job, bring me some proof of that when you come back. If not, bring me proof of where you've applied, okay? In the meantime, also, I want you to be talking to some attorneys so you know how much they cost. And bring me the names of those you've talked to, then we'll discuss what your options are, okay?
Okay.
So if you still haven't found a job, there may be a time when you qualify for a court-appointed lawyer, but I want you to at least go through this process. I want you to try to get a job, and I want you to try hard before that next court date, okay? All right, step in front of the clerk. She'll give you a reset notice. Good morning, sir. You're Brianna Clayton?
Yes, ma'am.
Not very smart to be doing anything while you're waiting on court, is it? How old are you? You're 20. So it is time to make better decisions, because smoking marijuana or anything else that has THC in it is going to be a violation of any probation, and it can put you in prison. It's that serious for you to get your life on a different direction. Make sense? All right. Now I can't remember how far I got at all. Let's start over. And she'll waive the formal reading of the indictment.
So waived.
Did I go through it all or no?
You got real close. We had just mentioned the misdemeanor cases. One was being dismissed, one was being run concurrent.
Okay. So we've already gone through, and she entered a plea of guilty. We went through, it was a 3-year deferred, $250 fine. All right, so we're gonna start back where we left off, Ms. Clayton, and let me go back and ask, did you enter your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? And then you understand what your punishment is that you're agreeing to, which is a 3-year deferred with a $250 fine, correct? With the dismissal in one of the misdemeanors, and then my understanding is you're gonna go plea on the other misdemeanor for a probation as well, correct? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Clayton is not competent?
None I'm aware of, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. If you test positive for anything between now and when you come back, you run the risk of me not accepting your plea agreement. Do you understand? I want her tested when she goes in for her PSI.
That's alcohol.
And I ran, yeah, that's alcohol also. You don't need to be using anything. No alcohol. You're not even legal to drink alcohol. So by your reaction to Mr. Kimler, it shows me that you're doing that as well. You understand you can go to prison for 10 years because of this? What y'all did, I mean, y'all jumped out of the car and hid and ran and all kinds of stuff. And it's not funny.
I'm not trying. I laugh when I get nervous.
Okay. I mean, you're lucky that this didn't turn out worse with you guys running and hiding from the police. It could have been very bad. So if you want your life to go in a whole different direction, you're going to have to make some much better choices. Okay? All right, so you need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there, and we'll see you back at sentencing.
Thank you, Your Honor.
Good morning, sir. You're Bart Thibodeau? And Mr. Thibodeau, were you able to get a lawyer hired?
The one I've been communicating with, I just started my new job this morning. After I get out of here, 30 days wasn't near enough time, around that $4,000.
Where are you starting to work?
Chevrolet car dealership and so.
Let me look at something real quick.
I have a rent house that's been keeping me afloat barely, but I mean,
As a condition of your bond, were you required, or did I, or the magistrate require you to wear a drug patch?
No.
Okay, you've been getting that done like you're supposed to.
I can get it off, because I mean, now that I'm working 5 over there at that dealership.
You're not gonna get it off as long as this is pending. So what I'm gonna do is give you 30 more days. Who are you talking to?
Justin Gilmore.
Okay, so I'm gonna give you 30 more days to try to get him hired. If it's not gonna work out with him, then talk to at least 3 others.
I'll talk to like 10.
Okay.
They all want the same thing.
Okay, let's see what you can do in the next 30 days. Also, bring me a pay stub since you've started working, and then we'll see what your options are at that point, okay? All right, step in front of the clerk, please, sir. Morning, Mr. Parker.
Morning, Judge.
Good morning, sir. Are you Daryl Albritton?
Yes, ma'am.
And Mr. Albritton, did you get someone hired?
I'm still looking. The good news, they got me working 7/12. They could have just started so I could be able to afford one.
Good.
They high.
Yeah. So who are you thinking about hiring? Or who'd you talk to at least?
Well, I had talked to all of them.
Can you tell me who they are?
Justin, Orlando, Tristan, LeGrand, Michael.
Are you just telling me their first names? Tell me the
No,
full.
their first name and their last name.
Michael Trent,
Yeah.
Tristan LeGrand,
Where are they?
Orlando Nealon.
Well, 2 of them in Harris County.
Okay,
The rest of them out here.
okay. So,
Some more too.
okay, so I'm gonna reset your case one more time. It sounds like if you're working that much, you should be able to get somebody hired before. You've been coming for a little bit. It's time to get someone hired before that next court date, okay?
Yes, ma'am.
All right, step in front of the clerk. She'll give you a reset notice. Good morning, sir. Are you Ryan Remy? And Mr. Remy, this is your initial appearance in cause number 25 DCCR 1246. You're charged with the state jail felony offense of driving while intoxicated with a child under 15. And that's from December 25th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Are you working? All right, so since you've made bond, I expect you to at least try to hire one. So what I'm going to do is reset your case for about 30 days. If you get someone hired before that next court date, then bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of those that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand?
Yes.
All right, step in front of the clerk. She'll give you your reset notice. Good morning, sir. Are you Terrell Coker? And Mr. Coker, this is your initial appearance in cause number 25 DCCR 1221. You're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Talked to Mr. Samuel.
Uh-huh. Okay, so what I'm gonna do, Mr. Coker, is reset your case about 30 days to give you some time to get him or someone else hired. All right, if you get him hired or whoever, just bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you a reset notice. Good morning, ma'am. You're Tiffany Elair? And Miss Elair, were you able to get someone hired? Mm-hmm.
Since this case was, had to resign from education, that's why I felt right here. I took money.
Speak up just a little bit.
I had to resign.
Okay.
So I took money out of my TRS to go ahead and pay for a lawyer.
Okay.
Instead, I'll be meeting with him Friday.
Okay, perfect. So what I'll do is give you 30 days to get him hired. Bring the reset notice that you get to him and he'll tell you what to do. If for some reason that's not going to work out, then make sure you either get someone else hired or visit with some others and bring you those names, okay? All right, it was Kyle Walker. Good morning. You're Jalen Eli?
Yes, ma'am.
And Mr. Eli, this is your initial appearance in cause number 25 DCCR 1004. You're charged with the state jail felony offense of forgery of a financial instrument, and that's from August 8th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am.
You already hired someone?
I ain't hired no one, but I'm like in the process of hiring
Okay, who are you going to hire?
Bronx. I don't know.
Burbank?
Yeah.
Okay. So what I'll do, Mr. Eli, is reset your case about 30 days to give you some time to get Mr. Burbank hired. If you get him hired before the next court date, just bring the reset notice. You need me? Oh,
You need me now or?
no. I'll come visit with you later, thanks. If you get him hired before the next court date, I had to rewind for a second. Did you see that? It happened. If, just bring the reset notice to him, he'll tell you what to do. If for some reason, go ahead.
I was saying, I work at FedEx long with 5 hours from Monday through Friday, so it's 30 days. It's kind of hard for me to get.
So it's going to be a little bit longer anyway, just holidays and things like that. If you're not getting enough hours, you might want to go out and try to get another part-time job or something like that as well. Perfect. So just see what you can do to get him or someone hired before the next court date. If it's not going, if you make payments toward him, then bring me receipts. If you're working, maybe bring your pay stub so that I see how much you're working. Bring whatever you can bring me that will help, okay? If it's not going to work out for some reason with Mr. Burbank, then visit with at least 3 others. You'll see they all charge different amounts, have different payment plans, and we'll discuss your options when you come back. If you do all that and need some more time, then we'll work with you, okay? All right, step in front of the clerk. Good morning, ma'am. You're Crystal Latulis. And Ms. Latulis, were you able to get someone hired? All right, who'd you talk to?
I talked to Marcus Wilson, Yolanda Law Firm, the Gulis, Leslie Law Firm.
The what? Say the last one?
The GERTZ
Oh, Gertz, uh-huh.
Law Firm, and Amanda and James Macon.
Uh-huh.
And his house.
All right, and so where are you going to be able to get somebody hired? Are you working? Okay, where you work? Okay, so what I'm going to do, thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, okay? Step in front of the clerk and she'll give you that. Good morning, ma'am. You're Lisa White. Come on up. And Ms. White, were you able to get someone hired?
I went to I paid for a consultation with Mr. Rojas and Mr. Samuel and Mr. Cody Crenshaw for $30,000.
Okay, and are you working?
I started unemployment this week.
Okay, so what I'm going to do, Ms. White, thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely because you're going to swear under oath that it's all true and correct, okay? Step in front of the clerk, she'll give you that. So weird, like his didn't print together on the docket. This one? Good morning, are you Rakeem Allen? And Mr. Allen, this is your initial appearance in cause number 25 DCCR 1163. You're charged with the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from June 7th of 2025. And then in cause number 25 DCCR 1164, you're charged with possession of a controlled substance, and that's also from June 7th of 2025. Since you've made your bond in your cases, have you had an opportunity to try to hire a lawyer?
Yes, ma'am.
So have you hired someone?
Not fully, but I'm for he basically my lawyer. I go pay him today.
Who's that? Okay. And are you wearing a drug patch?
I don't know, man.
Were you ordered to wear one?
I was, but once they changed my bonding company, they professionally didn't tell me about one.
So, but the magistrate told you had to wear one when you got out of jail, right?
You know, I'm on 2 different bonds. So I guess the other money I had already got done paying them off, so I didn't have to pass for them anymore.
Okay, so you're gonna have to wear one for me, but what first we're gonna do this morning is have you tested to make sure you're clean. Have a seat in the jury box. Good morning, are you Terrence Currington? And Mr. Currington, this is your initial appearance in cause number 25, DCCR 1114. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from July 13th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? I'm sorry? Okay, so what I'm going to do, Mr. Currington, is reset your case about 30 days to give you some time to try to hire someone. If you hire someone before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk right here. She'll give you your reset notice. Good morning, ma'am. Are you Kayla Provost?
Yes, ma'am.
And Ms. Provost, did you get someone hired?
I've been talking to Mr. Langston.
Okay.
And I reached out to Ryan Kemper, but I think I'm gonna go with Langston.
Okay.
However, I haven't got a job yet, but my teacher, I had graduated school like 5 months ago.
Uh-huh.
And she reached out to me for an internship that was supposed to start today.
Okay.
So.
Is it a paid internship or?
Yes, it's supposed to be paid.
Okay.
For laundry.
I'm sorry?
For laundry.
Okay.
So, yeah, I was gonna reach back out to her to see if I could start tomorrow.
Okay, so if what I'll do, Ms. Provost, is I'll give you another reset to get you hopefully started on that job and where you can hire one of those attorneys. If that works out, great. Just get them hired and bring the reset notice to them, and they'll tell you what to do. If for some reason it's not going to work and you're not making that kind of money or whatever, bring me a copy of your pay stub if you are working, and talk to some other attorneys and bring those names, and then we'll discuss your options. Okay? All right, step in front of the clerk. She'll give you your reset notice. Good morning. You're Whitley Shepard. Okay, and Ms. Shepard, this is your initial appearance in cause number 25, DCCR 1146. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 1st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Ms. Shepard, is reset your case for about 30 days to give you some time to hire one. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to when you come back, so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? Also, a tracksuit type thing is not appropriate for court. You need to wear something else next time. Do you understand? Yes, ma'am. Step in front of the clerk. Good morning, sir. You're Kyle Whittington. And Mr. Whittington, this is your initial appearance in 2 cases. The first is 25 DCCR 0924. You're charged with possession of child pornography, and that's from July 29th of 2024. And cause number 25 DCCR 0925. You're charged with online solicitation of a minor under 14, and that's also from July 29th of 2024. Since you've made bond in your cases, have you had an opportunity to try to hire a lawyer?
Not yet.
So what I'll do, sir, is reset your cases for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Okay.
If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to when you come back, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Understood.
All right, if you'll step in front of the clerk, she'll give you your reset notice. Good morning, sir.
Good morning.
Are you Farrell Gilbert? Is it Farrell or Farrell?
Farrell.
Farrell Gilbert. And this is cause number 25, DCCR 1009. Mr. Gilbert's charged with driving while intoxicated, 3rd or more. And what is the announcement?
I just picked up the media footage today, so I just need some more time to reviewing that.
Sure. Any issues? So, Mr. Gilbert, I'm going to reset your case about 30 days or so. Make sure you make an appointment. Go visit with your attorney now that he's gotten all of the media. Y'all can go over everything, and we'll see if we can get an announcement at the next court date. All right. Thank you. Y'all are free to go.
Thank you, Judge.
Come on in.
I have an 18-year-old today.
That's crazy. You're getting old.
18?
Yeah, he turned 18 today.
Good morning. Are you Dalton Frege? And will your client waive the formal reading of the indictment? Mr. Frege, in cause number 25, DCCR 0404, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from February 6th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they've charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
And do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Frege is not competent?
Negative.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. It'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right over there. Okay, we'll see you back at sentencing.
Thank you, Your Honor.
See, Valerie Hale.
What began as a routine courtroom docket quickly turned into a powerful lesson about accountability, responsibility, and second chances. As one defendant after another stood before the judge, the message remained. Good morning. Are you Dan Fair? The court expects action, not excuses. A young woman was warned that continued drug or alcohol use could destroy her future and even lead to years of reading of the indictment. Despite being offered a deferred sentence and another opportunity to change her life, other defendants were instructed to actively seek employment, hire legal counsel, and comply with every court order. Mr. F.A. Cost number 25 DCCR 0404. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 6th of 2025. And how do you plead to that charge rather than rushing to punish? Are you pleading guilty freely and voluntarily defending guilty because you actually did what they've charged you? I have here on the computer some documents that have your signature on them. The hearing begins with what looks like a routine guilty plea. But Judge Raquel West immediately makes it clear that this is anything but routine. Brianna Clay has already admitted guilt and is hoping the court will honor a deferred probation agreement. But before that can happen, the judge delivers a stern warning that every decision made from this moment forward matters. Drug use, alcohol, or violating even a single probation condition could destroy the opportunity she's been given and expose her to years behind bars. The court paused the sentencing to order a pre-sentence investigation, signaling that the final outcome will depend on far more than the guilty plea alone. Throughout this hearing, the judge repeatedly emphasizes accountability, personal responsibility, and making better choices. The question now becomes whether this defendant will take advantage of the second chance or risk losing it before sentencing even on them that the state has marked as exhibit.
I'm going ahead. I want to question the lawyer. He's not representative.
Here's the thing, you don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not, just because
Can I speak?
Nope, not while I'm talking. I already gave you an opportunity earlier, and I'm going to give you an opportunity in a minute, but I want you to listen carefully to what I have to say first, okay? Are you Justice Larzo?
Yes, ma'am.
And Mr. Larzo, in clause number 26, DCCR 0770, you're charged with the third-degree felony offense of obstruction or retaliation from March 8th of 2026 Your indictment alleges that you were previously convicted of assault on a peace officer and assault on a public servant on October 12th of 2023, both of those cases on the same day, which means if you go to trial and are found guilty in these cases, or this case, and those prior offenses are true, that means you would be considered a second-degree felony for punishment, which is between 2 years up to 20 years in prison. Do you understand all of that?
You can repeat that for me?
What part of it do you not understand?
The first part,
What you're charged with?
the part where you said,
So here's the thing. You're charged with obstruction or retaliation.
correct,
The offense date is March 8th of 2026,
correct,
and that's a third-degree felony.
correct.
The indictment also shows me that you were already convicted of 2 other felonies on the same day. What that means is if those are true, or at least one of them is true, it would enhance your punishment in this case to a second-degree felony, which means if you go to trial, you're found guilty, the range of punishment is between 2 years and up to 20 years instead of 2 to 10. What?
I would like to take care of this today.
Well, talk to your attorney and listen to what he has to say. And if y'all want to take care of it today, then there's some paperwork that you have to go over with and sign, and then we'll go forward. All right? You can go back with the bailiff. All right, Mr. Larzo, what's going on?
I'm going ahead. I want to request a new lawyer. He's not representative.
Here's the thing. You don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not, just because
Can I speak?
Nope, not while I'm talking. I already gave you an opportunity earlier, and I'm going to give you an opportunity in a minute, but I want you to listen carefully to what I have to say first, okay? Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney, and another attorney is not going to come get a different offer.
Okay.
So, Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on,
I want a new lawyer. I don't.
hold on. I understand, but listen,
Want to let me speak, man? Please, can I speak?
I'm going to let you speak, but I'm going to give you what your options are, okay?
I just want. All I want is what I'm saying. You trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say he already told me the other day that he working for the DA? He already said.
sure
I said you haven't. He have not asked me what happened. He haven't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzo, you're not in charge and you're
I'm
not
not saying
asking a
I'm not in
question.
charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's the evidence. That's
the
what he's telling you the evidence is what's in.
That's what the police report said, but he hasn't asked me my side.
And here's the thing. Your side is important if if you didn't do it, what his job is to tell you this is the evidence they have against you. You can take this deal, or if you say you didn't do it, you can go to trial. So if you're saying you didn't do it, then let's get a jury to determine if you did it or not.
I haven't seen no police report. I haven't seen no body cam footage. I haven't seen no evidence to where I can tell you if I'm ready to go to trial.
Is there media in this
Judge,
case?
as Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Let's do this. Do you have some media?
Judge, I have requested the media. What I told Mr. Larzo yesterday when he told me he wanted to watch the video, I told him we could reset the day to look at the video. He just said he didn't want to do that. He just wanted to come in and ask for a new lawyer.
I want a new lawyer because you now represent me effectively. You come to me and tell me the DA said this.
Mr. Larzo, he's just said that yesterday he would bring the video. Don't talk over me. He would bring the video for you to watch. I'm going to reset your case for 2 weeks. He's going to bring the information. You can watch it and you can make your decision. The offer is what the offer is. The DA's already said that. I don't care if you take it or if you don't take it. Take it, fine. Don't take it. We'll get your case set for trial. You need to be respectful. Mr. Rojas is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff.
May I ask a question?
Go,
please?
nope, I'm done today. Go back with the
I'm not
bailiff.
understanding how you can give somebody 4 years for an aggravated charge. Let's go. And try to offer me 5 years for non-aggravated. All right. Let's go.
Right, ma'am, are you Kashonda Riley?
I know it's a big ask, Judge, and it's not something that the court, I think, probably is leaning toward, but we're asking the court to consider probation in all these cases. Ms. Riley is 27 years old. She's got 2 young kids at home. As you can see from the PSI, most of her previous offenses are theft or some type of deception cases. And certainly she's old enough to know better. She should know better. I think if you look closer at her background, it's a situation where she never really had a chance to get any kind of direction in her life. She was placed into CPS custody when she was 3 months old. I think she lived with her aunt until she was 14. I think all that time, or most of that time, her mother was in prison. And when her mother got out of prison, Ms. Riley went back to live with her mom. From 14 to 17. At 17, she ran away from home. And I think her father's in prison now. I don't know how long he's been in prison, but he's in prison now. I think the easy thing to do is to go ahead and send her to the state jail. Not only for the court, the easy thing for Ms. Riley would be to send her to the state jail so that when she gets out, her slate is clean. She starts all over. I don't know that that's going to... I think if that happens, Judge, she's probably going to be back in the same place she's at, committing offenses, committing more thefts. What I'm asking the court to do is consider probation with possibly ISF, the cognitive track of ISF, so that she can get some direction, hopefully start learning how to make better decisions, and get her life onto the right track.
You were on probation. You've had 1, 2, 3, 4, 5, 6, 7 probations. 7. You were given a probation for this felony, and 4 months later, you picked up 2 new theft cases. You've had every opportunity for whatever help it is that is out there. It's not like you've just taken time and not had opportunities with probation to help you. And so at this time in cause number 24, DC, excuse me, 24, DCCR 1778, I'm going to find that you entered your plea to true, freely, and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 26, DCCR 0210. Find that you pled guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, clause number 26, DCCR 0211. Find sufficient evidence to find you guilty of theft of property. Find you guilty of that offense, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. There's a real easy way for you to stop being incarcerated, and that's to stop stealing. You can't expect to keep doing the same thing and not have more harsh consequences. And so you need to understand that when you get out of state jail, if you do this again, it's going to get worse every single time. So if you want to be there for your kids and break the cycle, then that's going to be up to you to break that cycle. All right. So Mr. Mink, in cause number 23, DCCR 1851, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle. And that was a 4-year deferred probation. Is that correct? And in cause number 24, DCCR 0294, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for aggravated assault with a deadly weapon, a 2nd-degree felony, and that was a 6-year deferred probation. Is that correct?
Yes.
Okay. All right. I'm going to find in each of your cases that you entered your pleas of pleas are true to counts 1 in the one case and then 1, 2, and 3 in the other, freely and voluntarily. Find all of those counts true. In cause number 23, DCCR 1851, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 0294, find counts 1, 2, and 3 true. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case. The 2 cases or the 2 sentences will run concurrently, which means together at the same time. Shows that you were placed on probation January 25th of 2023 for the 3rd-degree felony offense of obstruction or retaliation, and that was a 3-year deferred probation. Is that correct? The motion alleges that you violated your probation. Is that 1 through 5?
It is, Your Honor.
Count 1 alleges that you provided a urine sample June 26th, October 15th, and November 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Yes, ma'am. True.
That's marijuana.
It is true.
Okay. Count 2 alleges that you failed to successfully complete the GED program as directed. Is that true or not true?
True.
Count 3 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you tested positive for alcohol June 26th and October 15th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening October 14th of 2025. And is that true or not true?
True.
And then count 5 alleges that you failed to successfully complete the moral recognition therapy program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probation and extend it for 2 years. Order that you enter and successfully complete the JCDI program, which would also include a drug patch. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted any evidence that Ms. Berdine is not competent.
No, Your Honor.
So I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I do want to get an updated report. So we need to figure out between now and then what I can do between now and then. I just want to make sure that probation also agrees that that's all of the treatment and everything that's necessary. I'm willing to set a bond, and she's on probation. She can go ahead and start those programs. But I want to make sure, I think, that we're covering everything, if that makes sense.
Judge, she's been incarcerated for a while. Would the court consider PR?
Yeah. So what I'm going to do, Ms. Verdine, is I'm going to reset your case for sentencing. I'm not going to sentence you and extend it today. We're going to do that later. But I am going to reduce or set a bond for you in the amount of $1,000, but make that a personal bond, which means you don't have to pay any money. You're just going to get out of jail. You're still on this probation. You're required to do everything, including starting that JCDI program. You have to have a drug patch on within 24 hours of your release from custody. If you don't do that, I don't have to go along with this agreement when you come back. If you test positive between now and then, you're going to be right back in jail. Do you understand?
Yes, ma'am.
You can talk to your probation officer about where to get that drug patch. They'll help you with that, and then we'll see you back at sentencing, okay?
Yes, ma'am.
All right, you can go back with the bailiff.
I have a question.
Hang on just a second.
Is the drug patch right now just going to be a condition of a bond, or?
It's going to be both.
Okay.
It needs to be a condition of probation and bond. Yes, ma'am.
I forgot what I was going to say.
Sorry.
I forgot.
Today's courtroom session highlighted a consistent message from Judge Raquel West. Accountability comes before leniency. Whether addressing defendants seeking probation, requesting more time to hire an attorney, or entering guilty pleas agreements, the court repeatedly emphasized that every opportunity carries serious responsibilities. For Brianna Clay, sentencing was delayed while a pre-sentence investigation gathers additional information. But the judge warned that any violation before the next hearing could jeopardize the entire plea agreement. Rather than handing out automatic punishments, the court balanced fairness with firm expectations, reminding every defendant that future choices will ultimately determine future outcomes. Cases like this demonstrate that second chances exist, but only for those willing to earn them through their conduct.